Your dual citizenship status, the one you may have held quietly for years without a single issue, could suddenly come under serious examination in January 2026 because of new regulations that most people still know absolutely nothing about. For millions of dual citizens residing in the United States, and for Americans who also hold citizenship in another country, the law modifications taking effect next January could directly impact your passport validity, your ability to travel freely, your tax obligations, and in some extreme situations, even put your citizenship status itself at risk. And here's the part that's catching people completely off guard. Many of those affected won't realize there's an issue until they're already flagged by the system. If you are a dual citizen, if you inherited citizenship through your parents or grandparents, or if you're even considering becoming a dual citizen in the future, what I'm about to explain could save you from serious legal complications that are already beginning to surface behind the scenes. These modifications aren't theoretical, they're not rumors, and they're not something you can afford to ignore. Because once enforcement begins, fixing mistakes becomes far more difficult. Welcome to U.S. Policy Brief, your reliable source for the latest U.S. immigration news. I am your host, Fernando, and today I'm going to walk you through the most important dual citizenship law updates taking effect in January 2026. What's actually changing, who is most at risk, and what you need to understand right now to protect yourself. This isn't about panic, and it's not about politics. It's about awareness. Because the reality is, many people have been operating under outdated assumptions about dual citizenship for years. They believed that as long as they followed the regulations when they first applied for a passport or naturalized as a citizen, everything else would take care of itself. Starting in January 2026, that assumption is no longer safe. The U.S. government is fundamentally changing how it tracks, cross-checks, and evaluates dual citizenship, and the systems being rolled out are designed to catch inconsistencies that were previously overlooked. By the conclusion of this video, you'll understand exactly why January 2026 is such a turning point, which everyday habits could suddenly raise red flags, and how to stay compliant before these regulations start working against you instead of for you. I want you to feel informed, prepared, and confident about navigating these changes rather than anxious or overwhelmed. What makes these modifications especially important is that they're not coming from a single new law that was loudly debated or widely reported. Instead, this is the result of multiple government agencies updating their policies at the same time, quietly but deliberately. The State Department is revising how passport applications are reviewed. Homeland Security is updating how citizenship data is monitored. Customs and Border Protection is enhancing how travel records are analyzed. And the Internal Revenue Service is tightening how citizenship information is matched with tax reporting. Each of these updates might seem manageable on its own, but together they create a level of scrutiny that simply didn't exist before. For years, enforcement in this area was inconsistent. Disclosures were often taken at face value. Databases didn't always communicate with each other, and many dual citizens, whether intentionally or unintentionally, operated in gray areas without consequences. January 2026 marks the conclusion of that era. The landscape is shifting dramatically, and those who fail to recognize this shift will find themselves facing unexpected challenges. The driving force behind these modifications is what the government describes as national security, financial transparency, and information integrity. From their perspective, dual citizenship introduces risks they believe were not being adequately monitored. They want to know when U.S. citizens are traveling on foreign passports. They want to identify individuals who may be subject to obligations in another country, such as military service or government employment, and they want to close what they see as loopholes that allow people to shift assets, income, or travel histories across borders without clear oversight. Whether you agree with that approach or not doesn't alter the outcome. The systems are being built, the data sharing agreements are already in place, and once enforcement begins, the burden shifts to you to prove that everything you've disclosed is accurate and complete. That's why understanding what's occurring now before January 2026 arrives is so critical. Waiting until the last moment or hoping that these changes won't affect you is a strategy that is almost certain to fail. One of the biggest misconceptions I want to clear up right away is this idea that nothing has changed for me personally, so I must be fine. Many of the people who will be affected by these updates have never had an issue before. They've renewed passports without problems. They've traveled internationally for years. They've filed taxes the same way they always have. But the modifications coming aren't about your past experience. They're about how your information will be evaluated going forward. Systems that once relied on manual checks are being replaced by automated cross-referencing. Answers you provided years ago are being compared against foreign records, and inconsistencies that never mattered before can now trigger reviews, delays, or investigations. In other words, doing nothing is no longer a neutral choice. Inaction itself becomes a risk factor in this new environment. That's why, in the next part, we need to start with the area where most people will encounter these modifications first, and often without warning, your passport. For many dual citizens, the passport application or renewal process is where problems will begin to surface, even if you've answered the same questions the same way for years. The regulations around disclosure are tightening. The penalties for incorrect answers are becoming more serious, and the government now has far more ways to verify information independently. And once a passport issue arises, it doesn't stay isolated. It can spill over into travel, taxes, employment, and even your family's immigration cases. So before we move on, keep this in mind. The goal here is not to frighten you, but to make sure you're not caught unprepared by a system that is about to start paying much closer attention than it ever has before. Knowledge is your greatest protection in this situation. Starting in January 2026, one of the most immediate and consequential modifications for dual citizens will appear in a place most people consider routine and harmless: the U.S. passport application and renewal process. For years, applicants have been asked a simple question: whether they hold citizenship in another country. But enforcement around that question has been inconsistent. Many people answered casually. Some misunderstood what counted as citizenship, and others didn't think ancestry-based or unused citizenships mattered. Beginning in January 2026, that era concludes. The State Department is rolling out a mandatory dual citizenship disclosure system that no longer relies solely on what you write on the form. Instead, your answers will be automatically cross-checked against foreign government records from countries that have information-sharing agreements with the United States, and that list is extensive. It includes most European countries, Canada, Mexico, Australia, Japan, South Korea, and dozens of others. The network of information sharing has expanded dramatically in recent years, and it continues to grow. What this means in practical terms is simple but serious. If the system detects that you hold or are legally recognized as holding citizenship in another country, and you did not disclose it on your passport application, your case will be flagged for additional review. At a minimum, this can delay your passport for months. For people who travel frequently, that alone can be disruptive. But the consequences don't stop there. If investigators determine that you knowingly answered no to the dual citizenship question while being aware of your other nationality, the government can treat that as a false statement on a federal document. That's not a technical mistake. It's a serious offense. In those situations, the State Department has the authority to deny your application, revoke an existing passport, and in extreme circumstances, refer the matter for criminal investigation. The stakes have never been higher for accurate disclosure. This is why relying on past experience is dangerous. The fact that you answered the same way before and nothing occurred does not protect you once the new system is active. The technology has changed, the information sharing agreements have expanded, and the enforcement priorities have shifted. What worked yesterday may not work tomorrow. Another important shift is how broadly the government is now defining what counts as dual citizenship for disclosure purposes. It's no longer limited to passports you actively use. If another country considers you a citizen under its laws, whether through birth, parents, grandparents, or automatic registration, you are expected to disclose that status, even if you've never applied for a foreign passport, even if you've never voted or resided there. From the government's perspective, eligibility itself can be enough to trigger scrutiny if it appears in foreign records. This is why people are being caught off guard. They're not hiding anything intentionally, but the system doesn't care about intent as much as accuracy. If the records don't match your answers, the burden shifts to you to explain why. And once your passport is flagged, that information doesn't stay confined to the State Department. It becomes part of a broader profile that other agencies can access. To understand why the government is taking this approach, you have to examine what they believe dual citizenship enables. First, there's the issue of travel transparency. U.S. authorities want to know when American citizens are traveling on foreign passports, especially to countries with strained or hostile relationships with the United States. If someone holds U.S. citizenship alongside citizenship from a country like Iran, Syria, or North Korea, and they've been entering those countries using a foreign passport without disclosure, that raises immediate national security concerns. Even when the country involved isn't considered hostile, the government wants a complete picture of where citizens are going and under what legal identity. Second, there's the financial angle. The United States taxes its citizens on worldwide income, regardless of where they reside. Dual citizens who maintain bank accounts, investments, or businesses in another country are viewed as higher risk for tax non-compliance, whether intentional or not. Enhanced disclosure allows the government to connect passport records with tax reporting in ways that weren't possible before. This interconnection of data systems represents a fundamental shift in how the government monitors its citizens. There's also a third factor that many people overlook: foreign obligations. Some countries impose mandatory military service, government loyalty requirements, or restrictions on citizens who hold other nationalities. From the U.S. government's perspective, a citizen who is legally obligated to another country, even if they've never been called upon, represents a potential conflict of interest. This becomes especially relevant later when we discuss government employment and security clearances. But the foundation for that scrutiny begins with passport disclosure. The passport is no longer just a travel document. It's becoming a central data point that ties together your citizenship history, travel behavior, financial reporting, and eligibility for certain rights and privileges. Think of it as the hub of a wheel, with spokes connecting to every other aspect of your legal and financial life. And this tighter approach to disclosure doesn't stop once your passport is issued. It follows you when you travel. Starting in January 2026, Customs and Border Protection is implementing enhanced entry and exit screening procedures at U.S. airports and land borders. When you enter the United States, officers will more consistently ask whether you hold any other citizenships and which passports you utilized during your recent travel. This information will be recorded and cross-referenced with airline passenger data and foreign exit records. If you arrive using your U.S. passport, but the system shows that you departed another country using a different passport, you may be pulled aside for secondary inspection. That doesn't mean you've done something illegal, but it does mean you'll be questioned about why you're using multiple passports and whether you've properly disclosed your dual citizenship status elsewhere. These questions can be uncomfortable, time-consuming, and potentially lead to further investigation if your answers raise concerns. For many dual citizens, this will feel intrusive because for years, it was common practice to use different passports depending on which country you were dealing with. That habit was often tolerated and rarely questioned. Under the new procedures, however, the goal is to build a complete, consistent picture of your movements. Inconsistencies, using one passport to depart a country and another to enter the U.S., can now trigger deeper questioning. If officers believe you're being evasive or providing incomplete answers, the consequences can escalate quickly. Trusted traveler benefits can be revoked. Your passport can be flagged for future travel. And, in more serious situations, the information can be forwarded to other agencies for review. The key takeaway here is that transparency is no longer optional. The system is designed to notice patterns, and once it does, silence or vague explanations can work against you rather than protect you. As this increased scrutiny continues to expand, the next area where many dual citizens will feel the pressure is taxation. For years, foreign account reporting regulations technically applied to U.S. citizens worldwide, but enforcement was uneven and often reactive. Many people either misunderstood the requirements or assumed that small accounts, inactive assets, or accounts held in their country of birth didn't really count. Beginning in January 2026, that assumption becomes risky. The Internal Revenue Service is implementing automated data matching between passport records, citizenship disclosures, and tax filings. In plain terms, if you disclose dual citizenship on a passport application, but your tax returns show no corresponding foreign account reporting, the system will notice. This automated detection represents a major advancement in the government's ability to identify potential non-compliance. You may receive an automated notice asking you to confirm that you truly have no foreign accounts, or requiring you to file amended returns with the appropriate disclosures. This process is designed to be fast, data-driven, and largely automatic, which means far fewer cases will slip through unnoticed. The days of hoping that your situation won't be discovered are rapidly coming to an end. The penalties tied to these requirements are not minor. For non-willful failures to report foreign accounts, penalties can reach $10,000 per year. For willful violations, the fines can be dramatically higher, up to the greater of $100,000 or 50% of the account balance per violation. These are not hypothetical penalties. They are actively enforced, and the number of enforcement actions is expected to increase significantly once the new systems are fully operational. What makes this especially dangerous for dual citizens is that intent often becomes a secondary question. If the records suggest you should have known about an obligation, ignorance may not protect you. And this is where many people get caught completely off guard. They assume that because they've never moved money intentionally or never tried to hide assets, they're safe. But from the government's perspective, undisclosed foreign accounts linked to a second citizenship represent a compliance gap that must be closed. Once your passport and tax data are connected, those gaps become far easier to identify. This leads directly into one of the most overlooked and misunderstood risks in the entire dual citizenship discussion: citizenship by ancestry. Many Americans are citizens of another country without ever realizing it. Citizen. With expanded information sharing between governments, U.S. authorities can now receive confirmation of that status, even if you never actively claimed it. If those records exist, and they don't match what you've disclosed on your U.S. passport or tax filings, questions will follow. And those questions can be deeply uncomfortable because you're being asked to explain a status you didn't even know you had. The new expectation is that you are responsible for knowing whether you hold citizenship in another country under that country's laws, not just whether you've utilized it. This shifts the burden significantly. It means that family history, ancestry, and foreign civil records suddenly matter in ways they never did before, and once that information enters the system, it doesn't disappear. It becomes part of your long-term profile, accessible to multiple agencies. And as serious as tax and passport consequences are, the next area affected by these modifications can alter careers, livelihoods, and future opportunities in ways many dual citizens never anticipated. One of the most life-altering impacts of these January 2026 modifications will be felt by dual citizens who work for or hope to work for the U.S. government, defense contractors, or any role that requires a security clearance. Historically, holding dual citizenship was not an automatic disqualification. It was considered a factor, something investigators weighed alongside your background, behavior, and demonstrated loyalty to the United States. Many people believed that as long as they primarily resided in the U.S. and used their American passport, their second citizenship wouldn't stand in the way. Starting in January 2026, that assumption becomes dangerously outdated. The Department of Defense and intelligence agencies are adopting much stricter guidelines that create a strong presumption against granting or renewing security clearances for individuals who actively maintain foreign citizenship. This represents a fundamental shift in how dual citizenship is evaluated in sensitive employment contexts. Under these new policies, simply stating that your loyalty lies with the United States is no longer enough. If you hold citizenship in another country, especially one considered a strategic competitor or politically sensitive, you may be required to take what's called mitigating action. In practice, that usually means formally renouncing your foreign citizenship and surrendering any foreign passports. And this isn't symbolic. Authorities will require documentary proof that the renunciation was completed according to that country's legal process. For many dual citizens, this creates an impossible dilemma. Some countries make renunciation extremely expensive, time-consuming, or legally restricted. Others don't permit renunciation at all unless you complete mandatory obligations like military service. This puts people in a position where maintaining family ties or cultural heritage directly conflicts with career advancement or even continued employment. The choices are often painful, and the consequences are significant, regardless of which path you choose. Even more concerning is that these policies don't just apply to new applicants. Existing clearance holders may be reviewed under the new standards, meaning a status you've held for years could suddenly be questioned. And this heightened scrutiny isn't limited to classified roles. It extends to federal contracts, sensitive research positions, and roles involving critical infrastructure. Dual citizenship that was once viewed as a personal background detail can now become a professional barrier. What's especially troubling for many is how little warning there is. People often discover this issue only after accepting a job offer, beginning a clearance process, or undergoing a periodic review. By then, the options are limited and the consequences can be severe. This shift reflects a broader government posture that sees dual citizenship not as neutral, but as a potential vulnerability. Whether or not that view is fair, it's the framework being implemented, and ignoring it won't protect you from its effects. The best approach is to understand these new standards before they affect you personally. Beyond careers and clearances, these modifications also reach into one of the most personal areas of immigration law: your ability to help your family. Starting in January 2026, U.S. Citizenship and Immigration Services is increasing scrutiny of family-based immigration petitions filed by U.S. citizens who also hold citizenship in certain foreign countries. If you're a dual citizen petitioning for a spouse, parent, or other family member, your second citizenship can now influence how your case is processed. In particular, dual citizens connected to countries listed as state sponsors of terrorism or identified as high risk for immigration fraud will face enhanced vetting. That doesn't mean your petition will be denied automatically, but it can mean significantly longer processing times, additional documentation requests, and deeper background checks that delay reunification for months or even years. For families already separated by distance and immigration backlogs, these additional delays can be emotionally devastating. The government's concern is that dual citizenship could be utilized to facilitate entry of individuals who pose security risks or who intend to misuse family-based immigration pathways. From a policy standpoint, they want to ensure that the petitioner's foreign ties don't create vulnerabilities in the system. For families, however, the impact is deeply personal. What once felt like a straightforward petition can turn into a prolonged, uncertain process with little transparency. Many petitioners won't understand why their case is moving so slowly, only to learn later that their dual citizenship triggered additional review. This is especially painful for families separated across borders, relying on timelines that suddenly become unpredictable. And as we move forward, you'll observe that this growing emphasis on dual citizenship doesn't stop with adults. It now extends to how the government documents and tracks children born into dual citizen families as well. Another group increasingly affected by these January 2026 updates is families with children who hold or may be eligible for more than one citizenship. Until now, the process of documenting a child's citizenship status was relatively straightforward. A child born in the United States automatically becomes a U.S. citizen regardless of the parent's nationality. A child born abroad to a U.S. citizen parent often acquires U.S. citizenship at birth as well, assuming certain conditions are met. But when that same child also acquires citizenship in another country, either through the other parent or through the laws of the country where they were born, the government is now requiring far more detailed disclosure than ever before. Starting in January 2026, parents applying for a U.S. passport or a consular report of birth abroad for their child must disclose every citizenship the child holds or is eligible to claim, even if that citizenship hasn't been formally activated. This means parents may be required to submit foreign documentation, confirming the child's citizenship status, along with written explanations outlining how they intend to manage the child's dual citizenship as the child grows older. For many families, this feels deeply intrusive, especially when the child is an infant or young minor. But from the government's perspective, this information matters long-term. Some countries impose mandatory military service, political obligations, or restrictions on dual nationals once they reach adulthood. U.S. authorities want this information documented early so there's a clear record if that child later applies for sensitive positions, government employment, or security clearances. Failure to provide complete and accurate information can result in passport delays, denials, or repeated requests for additional documentation that stretch on indefinitely. For parents, the message is clear. Dual citizenship for children is no longer treated as a minor administrative detail. It's a long-term data point that will follow them into adulthood. Perhaps the most unsettling modifications, however, affect naturalized U.S. citizens who retain their original citizenship after becoming American. While the United States does not formally require people to renounce their previous citizenship when they naturalize, the oath of allegiance includes language about renouncing allegiance to foreign states. For decades, this was interpreted as a political statement rather than a demand to give up legal citizenship. Many naturalized Americans continued to use their original passport for travel, voted in foreign elections, or maintained cultural and professional ties abroad without issue. Beginning in January 2026, that interpretation is tightening. U.S. Citizenship and Immigration Services is expanding its monitoring of whether naturalized citizens continue to actively exercise rights associated with foreign citizenship. This includes renewing a foreign passport, voting in foreign elections, serving in foreign military forces, or accepting positions with foreign governments. If USCIS determines that a naturalized citizen's actions demonstrate continued allegiance to a foreign state in a way that conflicts with their oath, the agency now has clearer guidance to initiate denaturalization proceedings. This is an extreme and rare measure, but the fact that it is being emphasized at all signals a significant shift. Denaturalization means the revocation of U.S. citizenship. And while it has historically been reserved for cases involving fraud or serious criminal conduct, the government is now signaling a harder line on divided loyalties. For naturalized citizens, this creates a chilling effect. Activities that once felt symbolic, cultural, or harmless may now be interpreted through a far stricter lens. And as we move forward, this heightened scrutiny doesn't stop with citizenship status itself. It extends to humanitarian actions, sponsorships, and even professional standing in ways that many people never expected. With all of these modifications in motion, the most important question becomes what you should actually do right now before January 2026 arrives. The first step is disclosure awareness. You need to review every place where citizenship information appears in your records: passport applications, tax filings, immigration forms, employment documents, and professional licenses. Inconsistencies are what trigger scrutiny. The goal isn't to over-disclose or panic, but to ensure accuracy and alignment across systems. The second step is understanding your tax exposure. If you hold or may hold citizenship in another country, confirm whether you have foreign financial accounts that require reporting and whether your past filings were complete. Addressing issues proactively is far safer than responding to an automated notice after the fact. The third step is documentation readiness. Keep records that demonstrate how and when you acquired citizenship, what obligations exist under foreign law, and how you've utilized or not utilized those rights. When questions arise, clear documentation can make the difference between a routine review and a prolonged investigation. Most importantly, recognize that January 2026 marks a shift from passive tolerance to active monitoring. The regulations aren't changing to punish people for having dual citizenship. They're changing to make dual citizenship visible in ways it never was before. And visibility means responsibility.